Ms. Critelli.
Thank you, Your Honor. May it please the court, I'm Lylea Critelli, and along with my co-counsel, Nicholas Critelli, we represent the applicants in this case, the Whitfield law firm and attorney Gary Gately. We are here on appeal today because the decision of the Court of Appeals is, if left as it is, would replace a whole line of case law with a new version of the continuing representation rule, which this court has yet to adopt. The district court disposed of this case on summary judgment based upon 3 emails that were sent by the plaintiff to Mr. Gately and the Whitfield law firm. All the parties agree that the alleged acts of liability in this case occurred in 2008, and that the petition would have been filed well beyond the alleged acts of liability. It's important that Mr. Gately and the Whitfield law firm deny any liability, any responsibility, and any wrongdoing in this case. And it is only in the light most favorable to the plaintiff on summary judgment that the district court found that if there was liability, the liability occurred and the statute of limitations expired before the filing of the petition. The 3 emails in this case were filed by the plaintiff January of 2009, December of 2009, and March of 2010. And in all 3 of those emails, the plaintiff exposed knowledge of not only the wrongdoing that she alleged happened in this case, but that the damages had already occurred. And on that basis, the district court gave her the benefit of the longest period of time, in that the district court did not consider the first email in which she said, I wished I would have done the right thing, even if I was not legally obligated to do so, and paid my mother's debts.
Well, I read the emails, and I understand what they say. The comeback, I suppose, is, well, was there a duty on the part of the law firm to say something? I mean, they basically, if I understand the record right, please correct me, the law firm basically stood mute on the question of whether the retirement funds, et cetera, could be used to satisfy debts in the way they were. So the high watermark maybe of the plaintiff's claim is that once these communications were passed on to the law firm, was there a duty of some kind for the law firm to kind of step forward and say, well, we messed up, or something like that? You understand my question? I think you saw it in the briefing.
I do, Justice Appel. And I would answer that by saying, if in fact the facts were of that nature, perhaps. However, in this case, the situation is such that there's not a hiding of liability if in fact there was liability. And
no affirmative, I'm sorry to interrupt you. I didn't see any affirmative anything, but I did see silence. Is that correct or not correct?
I think the silence, if in fact there was silence, was warranted because the plaintiff in her second email asked that the fees be reduced based upon these issues. And I would submit to this court that when someone tries to negotiate legal fees, there's no misunderstanding or any mix-up as to who the possible or potential person who caused the problem was. So this is not that case scenario. And I believe that to decide it on that basis would be erroneous. Ms. Skadburg said, well, because of these issues, I believe the fee should be reduced. And in fact, in the dissent from the Court of Appeals and the district court finding, that was given substantial consideration that she had asked for that concession.
As I read the Court of Appeals opinion, basically they adopt a rule that as long as the lawyer is representing the client, the statute of limitations can't start running. Is that the way you read it? That's
the way we are reading it, and that is erroneous on 2 bases. And the first being that even in the continuing treatment doctrine cases, if the patient has knowledge of the mistake or the alleged act of negligence, then that continuing treatment doctrine does not change the discovery rule. It begins to run from the point in time when you can show that they have knowledge of the error. The second problem with that is that the Court of Appeals has also created a rule by where if a law firm doesn't send a closing letter then there's no notice that the representation has ended because they didn't consider the date of the order that closed the estate to be the date from which the statute of limitations should be determined. So I submit to you that if there's a situation where a law firm closes a file, the court closes the estate, but the law firm, for whatever reason, never sends a letter saying, and here, by the way, is the order, and now our representation is terminated, well, that statute of limitations could go on ad nauseum, and that would seem to be the exact antithesis of what happens with the statute of limitations. Statute of limitations is to maintain the fact that there should be no stale claims. And while there are harsh results in many occasions because of the statute of limitations, this is not one of those cases. If you applied the continuing representation doctrine to this case, this court would have to say, yes, we adopt the continuing representation doctrine, and then you would also have to say, and not only are we not going to go from the date of the order, which has always been the law in this state, it's the date of the order, not the date that you receive notice of the order, but the date of the order. There would have to be two substantial changes in the law to that respect. And the third substantial change would have to be that this court would have to say, and we're not even going to look at knowledge in the discovery rule. So you'll have rewritten many decades of law on the discovery rule and have changed substantially the law in the state on when there's knowledge, when there is notice. The case that the Court of Appeals relied upon, and also the case that the petition relies upon, the Vasawi case, that did not rely upon notice. That relied upon that the injury had not occurred yet.
Counsel, do the emails establish as a matter of law that the plaintiff was on inquiry notice more than 5 years before she filed?
Yes, they do, Your Honor. In fact, the final one that the court relied upon was in March of 2010, which would have given her 5 years. I believe the date of the email was March 26th of 2010. And in fact, this plaintiff was in the office of new counsel a year before that. She was in the office of new counsel in February, and she had until the following March to file a lawsuit. So the district court found that there was no factual question as to whether or not she was in inquiry notice. In 3 separate occasions, she indicated that paying of those debts with that money was not legally required, that it was a mistake. And in fact, in the middle one, she asked for reduction of fees. The district court gave her the benefit of the longest period of time. The district court could have said the first email, but the district court didn't do that. The district court went with the 2 second emails, which is what this court has said. Give them the longest period of time, and that is exactly what the district court did.
Ms. Critelli, is the continuing representation doctrine flawed in its foundation or just under the facts of this case?
If the court chooses to adopt the continuing representation doctrine, this is not the case to do it with. The facts of this case do not support that. I'm not taking a position either way with the continuing representation doctrine because I don't think I have standing to do that. I think the problem is the facts of this case do not support adopting that. There is nothing here that would have given her more time. In fact, if she'd gone under continuing representation doctrine, as I understand that to be applied, it would have been from the date of the order closing the estate, and they still missed the statute of limitations by 1 day. The estate was closed on August 18th of 2010, and this lawsuit was filed on August 19th of 2015. Still 1 day outside. There is nothing that she can do with these facts that will save this lawsuit from the statute of limitations. If it ran from the date of the second email, which the court found to be the first email in December, this case was dead before she walked into new counsel's office. If it goes from the second date that the court chose in March, then new counsel had over a year to file this in a timely manner, and that didn't happen. This is not the case.
Wouldn't the right case, if we were to adopt a continuing representation theory to extend the limitations period, wouldn't it be one where the lawyer could still make some moves and resolve the problem, fix it? For example, a pending appeal.
Exactly, Your Honor. And that's why, if you look at the history of this doctrine, it's generally been applied in litigation cases where the process is still going on. There is no reason for the plaintiff to have to go out and find new counsel to correct an error which could be corrected by the final acts of the court or on appeal. And I believe that's what this court has found in other cases, that it is not a final case until that appeal is filed and decided. And then that point is when you have a case to be determined on whether or not there was legal malpractice or legal negligence.
And that's not what we have here. She
No.
had paid debts and you can't get that money back.
Exactly. And the thing is that the damage was done in 2008. If there was damage done by the lawyer, it was done in 2008. The discovery rule allows her then to be placed upon inquiry notice so that a reasonable person would know that there was a problem and they should further inquire into it. And that is exactly what she had the opportunity to do. And unfortunately, the harsh results of the statute of limitations sometimes come down on parties. But the court has decided the balance in that is that there's harsh results. There's also fairness to defendants, that there not be stale claims, and court resources should not be used up in deciding stale claims. For all those reasons, we'd ask that you affirm the decision of the district court and reverse the decision of the Court of Appeals.
Ms. Critelli, thank you. Mr. Riley.
Counsel, honorable justices of the Iowa Supreme Court, I am here on behalf of Michelle Skadburg. The issue presented in this case is whether a client who is aware that there was a problem in administration of the estate, but believes that it was the client's fault, under circumstances where the attorney does not disabuse her of that, is barred by the statute of limitations. And there are three separate reasons why she should not be barred. Number one, under the Zager versus Polishek case, the statute of limitations does not begin to run until the person knows or should have known of all of the elements of the claim, and that includes the first elements of a malpractice claim.
Let me ask you, you said that, I mean, the email that the district court relied on, I tend to agree with you, the first one wasn't enough for the inquiry notice, but the December 30, 2009 one, she says, paying off mom's debt with money that should not have been part of the estate was one of the issues that has arisen. Gary and I have talked through this, and what is done is done, but please take these kinds of things into consideration when setting the fee. You say that in that email she's blaming herself? I don't read it that way. I mean,
well, you read the whole email. She says there was miscommunication, okay? She says miscommunication, not you gave me bad advice. You know, and clearly in the first email she is, you know, thanking him for doing the best he can. Now they are talking about a number of issues concerning fees. Keep in mind the representation by Gately of this estate, which probably shouldn't have been open in the first place, began because one of his partners was handling a matter in connection with the death of her son and agreed to do it on a discounted basis. And so she's bringing up a number of issues that go to what the fees are, not the least of which is, I thought you were going to do this on this basis. But she refers to it as miscommunication. I do not believe that referring to a problem as miscommunication evidences an understanding on her part that the lawyer, there was no miscommunication. There was a lawyer who should have told her, you can't pay anything until the 4 months runs. So I don't
it seems to me she knows at this point that she's paid off her mom's debt when she didn't need to pay off her mom's debt.
Clearly she knew that.
Isn't that enough to put her on inquiry notice?
No, because she has to know not only that she sustained an injury, she has to know there was a breach of the duty.
She knows the lawyer told her to do that. That's what you allege.
Well, clearly, and by the way, I don't think
And the record seems to support that.
well, I don't think there's any question that that is a legitimate inference. This is not her coming in later and saying, you told me to pay it. The very first email references that fact. But just because the lawyer told her to pay and then it turns out that she paid debts she shouldn't have, that doesn't mean a layman understands that what the lawyer failed to do is say, look, Iowa law is crystal clear. You can't pay anything with very specific limitations until the 4 months runs.
The other thing, it does, am I right in the record that in March 2014, which was still within the statute if we go with this December 2009 email, you're already, on her behalf, requesting the records from the Whitfield and Eddy law firm, right?
That's correct.
So at that point, there's still, what, eight months or so to file a claim, right?
That's true, yes.
And that didn't happen, did it?
No, it did not. And in hindsight, obviously, I should have sued then. I wanted to get the records. We wanted to have discussion. And obviously, we figured, you know, well, when did the estate close? That's a good point to docket. And obviously, I'd have done this differently in hindsight. But again, at the end of the day, you've got to show either one, that she knew all of the elements, including duty, which I do not believe that those emails evidence. Take a look at the third email. She's still asking them, relying on Gately for advice. She's saying, is there any chance I can get these payments back because I paid them in error? So she's still looking to legal counsel for advice and counsel. So I don't think that evidences a client believing the lawyer's fault. In addition, separate and apart from the Zager versus Polishek requirement that she has to know all of the elements, you have the concept of fraudulent concealment, which very clearly in Pride versus Peterson has said the lawyer has a fiduciary duty and silence can constitute concealment. When your client is apologizing for making a mistake, when you now realize, oh my God, she has all this money that was hers outright that shouldn't have gone through, that would not have had to go through probate, free of claims of creditors. I told her to pay the bills, and now she's spent her money paying bills she didn't have to pay. I don't think a lawyer under those circumstances can stand mute and say, well, by the way, the fault is not yours, the fault is mine. I think that independently is a separate ground to uphold the Court of Appeals. I understand, and in fact, one of the reasons why, if you look at our initial brief, we raised continuous representation as the third of our arguments. I mean, I understand there are issues with respect to continuous representation, because does the policy apply or is it a flat, when does the representation end? I understand that. But again, even if you think there's a problem with continuous representation, you still have to have, when does she know that there was a duty and a breach of a duty, and what obligation does a lawyer have to tell her, no, no, it's not your fault, which she's clearly saying in that first email. That's when the lawyer should have said, no, it's not your fault. I should have told you the limitations that exist under Iowa law. And I would also say, if you read the Court of Appeals decision, they are not relying strictly on continuous representation. At page 12, they very clearly say, here Skadburg was aware of the error in prematurely paying debts, but there's a genuine issue of material fact as to when she knew of the cause of action. And so what that's basically the Zager versus Polishek idea.
But
And
counsel, why wasn't she on inquiry notice? Once she knows she paid her mom's debts, she didn't have to, isn't that enough to start the clock running? Those emails are undisputed. Where did the district court and Court of Appeals dissent go wrong?
Okay. Because again, she knows there's a problem, but she thinks she is the cause of the problem. Very clearly in the first email, she's thanking him for doing the best job he could and apologizing for being upset for what she clearly thinks is her mistake. With respect to the second email, what she is saying is, we have all these factors in terms of what I was promised, and there was miscommunication. I think that's significant. She's saying there was miscommunication, not you, Mr. Lawyer, didn't tell me what you were supposed to pay. And then thirdly, in the third email, she's saying, I still want advice, because she asked the question, can I get this back because I paid it in error? Now, I don't think that evidences a layman's understanding that it was the lawyer's failure to advise her. And this is something fairly basic. I mean, when someone comes in to open an estate, you know, the statute's very clear. You cannot pay anything until you're assured that there's enough money to handle costs of administration, and then you shall pay support allowances and may pay funeral and last illness. I mean, this is the basic thing. You tell people you can't pay anything until 4 months after publication. And here he says, go ahead and pay your mom's debts. and doesn't even check to see what the source of the money is, money that passes to her free of creditors. And so under those circumstances, I don't think you can say that she understands that the lawyer didn't tell her basic stuff about probate. And secondly, when she is taking the blame, shouldering the blame for herself, I think that's when the lawyer has an obligation to say, no, it was not your fault, it was mine. So for those reasons, I don't think that you can say that these emails, create inquiry notice as a matter of law. And again, any one of these three grounds, fraudulent concealment, knowledge of all of the elements, which includes knowledge of a duty and a breach of a duty, or continuous representation, any three of those is basis to uphold the Court of Appeals and reverse the trial court.
My concern is we're going to upend our law on inquiry notice, which to me means there's a problem, look into it, and she did. She went to you. That seems to be enough to start the clock running.
Right. But I have two responses to that, or two aspects to my response. I guess I have one response in two parts. Number one, I think it was the Duden case that very specifically distinguished the Franzen versus Deere case. And they said in Franzen versus Deere, you sustain a physical injury, you know you have a problem. Whereas in the context of legal malpractice case, you may know you have a problem, but do you know the lawyer caused it? That is, I think, one big distinction. And you see this in all of the cases that deal in the context of medical malpractice. When does the client really know? But I think in this case, you said very recently the client has to know all the elements, which means now they have to know that they have a problem. People who participate in the legal process have bad results all the time. Does every time you have a bad result mean you have to know that your lawyer caused the problem? I don't think so.
But don't we have here the email, or I don't know if it's an email or a letter from Mr. Gately then, that specifically tells her, since you're getting all the assets anyway, you can go ahead and take whatever money that you have and pay these bills, and that's back in 2008, shortly after the representation began, isn't it? That he specifically gives her that advice, I believe, and that's in the letter or email that says, since you're getting all of the assets anyway, you're the sole beneficiary, go ahead and pay all the bills and the rest of it's yours. Isn't that when the real cause of action accrues then? Or that she has knowledge, at least, that you told me to go ahead and do this?
Well, first of all, we don't have any communications in the record from Gately back to her. We have her reciting, you told me to go ahead and pay the bills, all right?
And maybe I'm mistaken. I thought there was an email that basically said, you're the sole beneficiary under, I think it was her mother's estate, and so go ahead and all the money that you get, you can go ahead and pay the bills, and because whatever's left over is yours. I thought there was some representation like that.
I believe that what's in the record is her statement saying, you told me to go ahead and pay the bills, specifically. And she says, I should have given you the entire list of debts and asked for more specific advice on what to do, but I just took you at your word to pay the debts and did that. All right. Yeah, and that's when she made the payments, that's when the claim, the elements of the claim would have been complete. But again, what we're talking about is the statute does not begin to run when all the elements are complete. The statute of limitations begins to run when she knows, or should have known, that she had the cause of action, and that means she had to know every element, and that means she had to know duty and breach.
So again, what's your position about the accrual of the cause of action here? Because that's what I'm really interested in. When, in your opinion, did the cause of action accrue? On the 31st of August? Is that the date that you're relying upon?
No, the cause of action accrues when she makes the payment. The question is, when does the statute of limitations begin to run on that accrued
But my
claim?
understanding is the statute of limitations begins to run when a cause of action accrues, and that's pretty well established. So that's where I'm a little confused about when you say that the cause of action accrued. It has to be that August 31st whenever he sends that final letter. Isn't that what your position is?
Well, our position is that that would end the representation and the statute would not begin to run until then. I mean, there's a distinction between when does the claim accrue, and that's when you have all the elements, duty, breach, causation, and damages. That happened when she made the payment. The question is, when does the statute of limitations begin to run? And our position is, it doesn't begin to run until after she closes the estate. She talks to people and realizes, I should have been told, don't pay anything. That's when she knows there's a breach of duty. Secondly, there was never a disclosure when you've got the client saying, I'm sorry that I did this, it was my fault, and the lawyer not saying, no, it was not your fault, I should have told you you can't pay anything. And finally, we don't think that it should begin to run until the representation concludes. So, I'll pass on the remaining 30 seconds and turn this back over to counsel.
Mr. Riley, thank you. Rebuttal, Ms. Critelli?
In this case, she was placed on inquiry notice, and she was placed on inquiry notice as early as January of 2009 or as late as March of 2010. And yet, she did not file the lawsuit within those parameters. Mr. Riley brought up the issue of concealment. There was no concealment in this case, nor was there any attempt to place her on the wrong trail or to hide the ball or to somehow protect the law firm if, in fact, they were negligent. According to Mr. Riley's scenario, unless a lawyer admits to liability in a malpractice case, he would say that that client was never on notice because the client did not know that the lawyer was negligent unless the lawyer admitted to negligence. And I would bring to the court's attention that even in medical malpractice cases, the court has said that there's no requirement that the patient know that the doctor's negligent. That is not one of the requirements under inquiry notice. Under the Sawi case, that was a situation where the damages were speculative. The alleged mistake had been made in drafting the documents, but the damage had not been done until the other party breached on the contract. And therefore, the court found that you couldn't have a statute of limitations start to run until there were damages. And that, to me, seems very basic, and to me does not seem to be what happened in this case. As the court recognized, if there were damages in this case, they occurred in 2008. If there was knowledge in this case, it occurred in 2009 or very early in 2010. The client was in new counsel's office. The court closed the estate in August of 2010, and yet we're trying to extend this case beyond even the court's closing of the representation. Representation ends when the court says it ends. In an estate, you have no authority to represent that estate once that estate is closed. There's no entity to represent. There's no executor to represent. There's nobody to represent. And the fact that there's an enclosure letter that refers you to that order and says, enclosed, please find the order that closes this estate, and this ends our representation, that's notice that the date on that order is the date that you go from. So even if the court accepts the argument that continuing representation should apply in this case, you still have the concept that this petition was filed one day too late. And as harsh as that may seem, this court has acknowledged that statute of limitations sometimes result in harsh results. But the trade-off is that the courts are not clogged with stale claims, that defendants are not forced to keep open their chance of liability or exposure beyond a specified time frame that has been determined by the legislature. For the reasons stated in the briefs and for all of the law that this court has on the books at this point in time, we would ask that you affirm the district court's decision and that you reverse the Court of Appeals decision. Thank you.
Ms. Critelli, thank you as well. Mr. Riley, thank you again. Case of Skadburg versus Gately is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.